迎各位。咁一陣間 CJ 會同我哋講幾句先嘅，講完之後咧，佢會接受大家提問。咁提問嘅時候，請講下你嘅機構同名之後先嚟開始發問。唔該晒 CJ。
大家好，首先新年快樂 ，Happy New Year to everybody。首先我想多謝大家出席我哋嘅一年一度嘅法律年度開啟典禮。好高興有機會一年一次見你哋。去年咧，依年咧，我哋嘅法官咧處理唔少案件，有啲案件咧係比較爭議性嘅。無論呢啲係民事案或者係刑事案咧，點解係爭議性咧？係因為好多呢啲案件咧係有政治啦，有時係有啲經濟或者社會嘅原因嘅。好多即係今年咧，好多評論者係評論我哋嘅工作，有啲係同意我哋嘅睇法，同意嘅判決，有啲唔同意嘅。我相信係唔同人有唔同嘅睇法，有時都有批評嘅。剛才你都聽我所講咧，啲人生嘅感激咧就好難接受嘅。即係如果係批評咧，應該有理據嘅。所以可以話我哋法官嘅工作咧，有時咧都唔係簡單嘅。但係無論有冇批評或者有冇人讚我哋咧，我哋都會係繼續係會為香港嘅服務。其實香港法官嘅使命咧，可以話係維護香港嘅法治，為香港嘅服務。其實我哋嘅挑戰咧，就係其實可以希望社會會支持我哋嘅工作啦，會對我哋有信心，會有信用。即係如果係市民大眾咧，係可以係了解我哋嘅司法制度咧，咁就大家都能夠可以了解我哋嘅香港嘅法治。我哋法治大家都知道咧，係香港嘅基石。但了解香港嘅法治咧，最需要記得咧，就係我哋有個獨立嘅司法機構。呢個係非常係重要嘅。97年後咧，你可以話嘅法律嘅環境有變嘅，即係好多人係用法律咧係保障佢哋嘅權利同埋自由。法官咧履行佢哋嘅職責咧，係依法處理啲案件嘅。呢個意思係咩咧？就係處理案件咧，淨係會處理啲有關嘅法律嘅問題。我講咗好多次㗎啦，係即係我哋唔會話決定社會嘅政治啲問題，或者一啲經濟嘅問題，或者係社會嘅問題。同埋咧，大家都要記得咧，人人咧喺法律面前係平等嘅，冇人可以凌駕上法律嗰度。我係好知道，就係我明白係社會對法官咧嘅要求係非常高，期望非常大。但係嘅要求同埋嘅期望係咩嘢咧？就係我哋處理啲案件咧，係完全依法處理案件，淨係睇啲有關嘅法律嘅問題，啲適用嘅法律。我而家係做緊第9年咧，香港嘅首席法官㗎喇。我仲記得咧，係8年前、9年前第一次同你哋見面咧，你哋問我嘅使命係乜嘢？我嘅使命咧，好簡單嚟講咧，都係維護香港嘅法治。呢個咧，我會繼續做嘅。有用英文講幾句啦嚇。So thank you for attending this year's opening of the legal year. This past year has seen the Hong Kong judiciary deal with a number of cases, whether in the civil or criminal context, cases which are controversial. And these are controversial because the origins of these cases are political, sometimes economic, sometimes social. A lot of commentators have made commentaries on the work that we do. Sometimes the commentators agree with what they see, sometimes they don't agree. Different people obviously have different viewpoints. Sometimes there have been criticisms made of the judiciary's work and of the way cases have been decided. And this can't be helped. Now, some of those criticisms where there has been personal abuse leveled at judges, this, in my view, is unacceptable. There has to be some informed way in which criticisms are made and some justifications for it. So it can be said that the work of judges is at times not simple. But whether criticisms or not, or whether praise is given to the judiciary doesn't really matter, because what judges do is to work for the benefit of the community. The mission of judges, if that's the right way of putting it, is to uphold the rule of law and to serve the community. Our challenge really is that society understands the work we do, hopefully supports the work we do, understands the legal system, because only in understanding the legal system can there be a true understanding of the rule of law in Hong Kong. Now, understanding the legal system requires, as the most basic principle, an appreciation of the independence of the judiciary. Since 1997, there's been a change in the legal landscape. More people, for various reasons, have resorted to the law in order to enforce their rights and liberties. But as far as judges are concerned, and I've said this many times, judges are only looking at the legal merits of a case. Whoever wins or loses depends entirely on the legal arguments and the legal merits. The courts are not there to solve and determine social issues, economic issues, and certainly not political issues. The expectations of society, expectations of the judiciary, are great, and there are great expectations of it. But what these really mean is that judges should really be deciding cases only looking at the law. Now, this is my 9th year as Chief Justice of Hong Kong. Remember when I first met ladies and gentlemen, that I was asked what my mission was. My mission remains what I said to you, which was my mission is to uphold the rule of law. And this I will continue to do. Thank you very much.
咁提問時間，我覺得你個名同記名先。會報專項文係啊，嗰個國歌條例草案咧，咁就提到咧係法官宣誓啊，係都要需要就唱國歌嘅，係點睇呢個安排，同埋點睇有啲人或者有啲議員咧，法官啊或者立法會議員宣誓咧，係將全國性法律嘅要求引加喺香港嗰度點解？
講國歌嗰條例咧，我就唔應該講太多。有兩個原因咧，一咧係未立法㗎嚇，第二咧就係可能咧將來會有啲案件嘅，所以我唔係太方便講太多。但我會講呢度啦，就係剛才咧嗰個典禮咧，法律年度開啟典禮咧，都聽到有國歌嚇，同埋咧將來即係同埋我哋宣誓咧嚇。呢種嘅場合咧嚇，呢啲儀式咧，對我哋嚟講咧係非常係重要嘅嚇，所以有國歌咧，我覺得係應該嘅嚇。嗱，其他方面咧，我就唔評論噶啦嚇。我諗大家都明白嘅，但係我哋對我哋司法機構嚟講咧，係呢兩種嘅儀式嘅咧，係非常係重要。有國歌。我覺得係應該嘅。點解係重要咧？係咪好似今日嘅典禮同埋宣誓嘅典禮咧？個儀式咧係強調即係我哋嘅 commitment to 香港嘅法治，所以係所有覺得係重要 重要嘅儀式嘅咧，有國歌咧，呢個係我覺得係應該嘅。其他啲方面咧，咁我就唔敢評論啦。Yes.
Chief Justice,
Hello.
The question to you, I'm from Reuters. Just regarding the C.Y. Leung incident, can you see any reason why overseas independent legal advice wasn't sought for this case? You mentioned during your speech the importance of society and the public hopefully supporting the work of the judiciary, and there have been concerns raised that perhaps there wasn't consistency of approach, of general principles regarding CY's case and Donald Tsang's case, which did enjoy the benefits of this external legal advice.
This is a question probably better directed at other people, the Department of Justice, rather than the judiciary. The judiciary has no responsibility in terms of deciding on prosecutions, who to prosecute, what the methodology is, what the procedure would be. So probably I'm not the person to ask, and I can't help, and nor in reality really should I comment in case somehow this matter progresses to a court hearing. But in terms of prosecution, it's not the responsibility of the judiciary.
But just in terms of the perception towards the rule of law as the guardian of one of the guardians of the rule of law himself, are you concerned at all?
Well, it's nice to be called a guardian of the rule of law, but I'm not a guardian of prosecution policy. So I think I would not be the right person to comment on this particular aspect.
Mr. Ma, two questions.
Alvin.
What do you make of the Alvin from South China Morning Post? First question: what do you make of the protest just now, as you see, directed to the Secretary of Justice? Is it your worry that it opens certain floodgates using this ceremony, which I understand is quite unlikely, quite unprecedented for such kind of protest to be taken at this occasion? My second question concerns with the...
can I answer your first? Otherwise, I'm going to forget what your question is. In relation to what has happened just now, again, I don't want to comment so much, except to say this. The purpose of the opening of the legal year is that everybody is gathered to talk about Hong Kong's legal system and to talk about Hong Kong and the rule of law in Hong Kong. This is the concentration of all the speeches, as it always has been historically through the years, rather than a vehicle for anything else. I think that's all I want to say in relation to what has happened just now. I think everybody saw what happened just now in there. That's all I have to say in relation to that.
I'll keep my second question short. In relation to the torture claim, do you have any concrete proposals in mind? Because you are aware that the executive has proposed a certain administrative amendments on the table. Are you thinking along that line, or are you thinking of reform on the tribunal side? Or, I mean, what drives you other than the efficiency? Is there a concerns on the impact that it has on the constitutional elements that Hong Kong has? Because a lot of these claims, when they raise to the higher level courts, it often encroaches on the constitutional elements.
The amendments which we have in mind, well, I'm not myself entirely clear about what the administration's proposed amendments are. I too have read the papers as you write them. But what we have in mind, as I mentioned in my speech, are relatively minor changes, and these deal with court procedure. And we will be, I think we have started dialogue with the Department of Justice, which is responsible for legislative amendments, but they are procedural amendments. And of course, in relation as to any amendments which we propose, we'll be asking all relevant stakeholders, meaning law society, the bar, and everybody who's affected. In relation to any constitutional implications, in relation to those, again, I'm not going to comment on this because, as with anything with a constitutional nature, it could end up in court. But what I wanted to emphasize excuse me, in the speech was the proliferation of cases. The exact figures can be given to you by the Judiciary Administration, but just to give you a rough idea of the increased workload of the courts, is that in 2016, we're talking about judicial review, applications for judicial review. In 2016, there were roughly 60 applications for judicial review in relation to this type of claim. 2 years later, 2018, that's last year, it had gone up to roughly 4,000. Sorry? 3,000 then, roughly 3,000, I'm sorry. In relation, this is the court of first instance. In relation to appeals, in 2016, there was one appeal relating to a refusal of leave, and in 2018, it was nearly 200. Now, all these cases, I say, require care because you have to look at the legal issues and as you said, Alvin, there may be constitutional implications as well. So that's a sort of figure. But for exact figures, perhaps you can contact the Judicial Administration, provide you with more accurate figures and more precise figures. Hello.
想關注就係點解連續即係都係幾年再提一次司法人員或者法庭受到攻擊咧？係咪你覺得個情況冇改善到，或者甚至有惡化嘅跡象咧？第二就係有關即係酷刑聲請嗰度，可唔可以都具體講下嗰個壓力有幾大，令到即係要喺呢種型嘅 opening 都要去向大家 address 呢個議題？
係。其實我就係點解我哋 address 咧，就係因為咧就係年年都有呢種嘅批評嚇，有呢啲批評咧就係嗰啲人身感激㗎啦嚇，唔可以話係特別擔心係有呢件事嘅，但我就係希望咧大家咧如果係批評係有理據批評，即係如果係想評論咧係有理據評論，同埋最緊要咧就係呢啲評論咧係即係有理據咧，即係等於英文咧就係。criticism and comment should be on an informed basis。所以大家係，所以我就強調乜嘢咧？就係大家要了解我哋嘅司法嘅制度。即係如果你係想知道咧，即係好簡單嘅問題，點解呢個法官係咁樣判㗎？嚇，點解係判有罪或者冇罪？and so on 嘅咧？其實睇咩咧？你就睇嗰個判詞，嗰個判案書 ，look at the judgment。呢個係其實係我嘅，唔係話擔心，如果我想大家就了解呢件事。
之前有一個問題，酷刑申請。
哦，一陣間係。
即係有關酷刑申請嗰度，點解都會即係特登喺呢個場合去提咧？係咪個工作量真係好大？可唔可以具體講講？即係咩跟住嗰啲 torture claims 嗰啲係咪工作量？係咪一係有啲即係對我哋嚟講有啲壓力嘅嚇？因為我哋嘅法官咧，你可以話係你知道係我哋有幾位即係幾多法官㗎啦？我哋差唔多係180嚇。全香港即係包埋即係 top to bottom 咧，都係180個法官。咁我哋嘅案件嘅量咧，個數量係幾大嘅。所以而家呢啲 torture claims 嗰啲咧係多好多。剛才已經俾咗你啦。2016年。係嗰啲司法覆核嘅嗰啲 application 咧係有60，2018年咧就變咗3000，差唔多3000㗎啦。所以你睇個壓力係即係對我哋嚟講咧係幾大嘅。咁我哋法官都係一樣喎，冇變過嚇。咁我哋都要處理其他嗰啲案件嘅，即係香港有第啲 litigant 嘅，咁佢哋都有等緊啦嚇。所以呢個係可以話係對我哋嚟講係壓力。Yes.
Greg Reuters. In view of some of the tensions that you outlined in your speech, I wonder if you think that the time is right perhaps to restart democratic reform as a way of protecting in the longer term Hong Kong's rule of law.
Well, I'm not going to get into a debate. I think you probably asked me a similar question last year. I'm not going to get into a debate about a political debate. I'm just looking at it from a narrow point of view of the law, and not really my place to talk about a democratic debate, much as I guess a lot of people might want me to. Not really my place, nor my in my responsibilities as Chief Justice. So.
關於 UJL 嗰度 其實關於 UJL 嗰度咧，你都話檢控唔係你嘅工作啦。咁但係你會唔會有個感覺就係，就算社會幾咁關注一件案件，只要 DOJ 唔告，其實個 court 都唔可以處理到。同埋你會唔會覺得 DOJ 喺呢件事上邊需要再解釋多啲？同埋都想問翻阿 SJ 頭先講嘅嘢，佢講到話普通法即係香港嘅普通法咧，有時唔應該去睇英國嘅案例，你點睇佢咁樣講法咧？
嗱，呢個兩件事嘅，即係佢哋告或者唔告咧，即係檢控或者唔檢控咧，呢個唔係嘅司法機構嘅責任㗎啦。即係譬如講，如果佢哋檢控，咁我哋係冇得話係你唔應該檢控㗎，除非佢根本係冇理據。但係咧，即係如果話我哋唔檢控咧，呢個我哋都冇可以控制。
但係需唔需要即係 DOJ 需唔需要再解釋多啲？同埋關於頭先 SJ 頭先講嘅嘢，
呢個你要問 SJ， 因為呢個對剛才講呢啲唔係我嘅責任㗎啦。你想問你問佢啦。
但會唔會對法官構成壓力嘅感覺？
都係完全冇關嘅，因為呢啲 prosecution 嗰啲係唔係我哋嘅責任嘅。
即係佢關於 common law 嗰度，即係話 common law 喺即係香港嘅 common law 有陣時 CFA 係唔應該去攞翻英國嘅案例去。
咁我哋係呢個係啱嘅，唔係自己睇英國係發生咩事。咁我哋都睇香港嘅情況係咩啦。咁有時我哋都要睇澳洲或者新西蘭嗰啲法律㗎啦嚇，唔係淨係睇英國㗎啊。因為大家都係一個可以話係 common law jurisdiction， 即係普通法嘅管轄區。
希望係咪有問題？
啊 ，hello。
想問下咧，即係都係申請嗰度啦，會唔會話即係具體有一個點樣修改嘅一個 proposal 啦？第二就會唔會話即係修改會俾人即係一個印象就係覺得香港想處理同人呢個申請啦，或者
即係嗰啲 torture claims 係咪？
第二條問題係先答咗。
唔係，呢第一個問題咧，就係剛才我都講㗎啦，係而家好似政府 propose 嗰啲咧，係我就唔係好清楚啦。但係我哋啲 suggest 嗰啲改例咧，係比較係講程序嘅法庭程序嗰啲改例嚇，所以係其實兩個係唔同嘅。即係第二個問題，都係講 torture claims， 唔係好。
信任其實係即係一路咁低人，同埋即係有啲人都會覺得即係提出咗話釋法就係凌駕咗成個香港司法制度，咁會唔會即係你自己點睇咧？會釋除到公眾？所以
你知道咧，我係緊張咩咧？我係緊張係唔好話緊張啦嚇，希望咧係市民大眾咧係對司法機構有信心，對司法機構有信心咧就等於係對香港嘅法治有信心嘅。喺呢度，所以我就係想大家咧，就希望大家係了解我哋嘅司法嘅制度嚇。所以好多時市民都係問點解咁樣判嘅？好似覺得好奇怪嘅，你係咪特別係偏幫依啲人或者係嗰啲人嘅咧？其實我嘅答案咧，你就睇佢個 judgment， 你就睇嗰個判詞，睇嗰個判案書最緊要最簡單咧，就係睇嗰個 judgment 嘅啦。我知道係好長，同埋可能都好悶嘅咧。但係咧，如果你想知道點解法官係判咧，喺嗰度就係你就可以了解啦。
Justice Ma, I'm from RTH, I'm from RTHK. I also want to follow up on the question on the national anthem. You mentioned just now during important ceremonies, we need it's appropriate to play the national anthem. Could you explain why is that important? Why is this so important? I think you answered that in Chinese just now. And also, I want to follow up on the question on public confidence as well.
Okay, let me deal with that question. I'm not as young as I used to be, so I might forget your question. Let me just give you an answer which gives you a bit of background, which is this. What is important for people to appreciate is the work of the judiciary and what it stands for. What it stands for is independence. I mentioned these qualities, which are these characteristics, which we all need to bear in mind, which is we had an independent judiciary deciding cases independently. Everyone before the court is equal. These are principles upon which the courts operate. Now, Then let's go into your question about the national anthem. Whether there exists a national anthem law or not, these abiding principles of how the courts operate, independently ensuring that everybody before the law is equal, that matters are decided according to law and not according to factors, whether political, economic, or social, won't change whether or not there's a national anthem law. And that's important to bear in mind as far as the judiciary is concerned. Now, you heard my answer, which was I'm not going to comment too much on the national anthem law, first because it's not yet been passed, and secondly, there may be cases which come up, not appropriate for me to say too much. And of course, thirdly, I'm not going to comment on the national anthem law insofar as it's perceived by other people. Now then, it's within that context and that background to answer your question about why I certainly would think it is appropriate to have the national anthem in important ceremonies. You've heard the national anthem played not just this year, but every year since 1997, and before 97, the UK national anthem was played. Another important occasion for the judiciary is the swearing in of judges. These are important occasions where I think it is appropriate and right to have the national anthem to emphasize the importance of those these occasions. And why they're important, as I answered this gentleman, is this, that these are occasions in which the rule of law in Hong Kong, with which I am acutely concerned, is dealt with. And it is important for me is to hope that members of the community will understand what the rule of law is about. These are therefore important occasions underlining the rule of law. The swearing in of judges is important because it is the judges who will uphold the rule of law. For these reasons, we take these occasions very seriously, and if the occasion, the seriousness of the occasion is underlined by the playing of a national anthem, which is common all over the world, then I think it is appropriate and right. I make these comments from the point of view of what the judiciary does and the occasions, the matters with which the judiciary are concerned. Not talking about future cases. I'm not talking about other contexts in which the question arises, say in the Legislative Council or anything like that. Not my place to talk about it, but I'm talking purely about the judiciary.
And second question, you said just now that you're acutely concerned about the rule of law in Hong Kong, and this is not the first year that you talk about public confidence in an independent judiciary and the rule of law. Do you see these two important core values in Hong Kong deteriorating, or public confidence going down these few years because of all the various controversies?
Well, I see a lot of, this goes back to what I've been saying about comments made, criticisms made, because on some quarters, many people will ask the question, what is the rule of law about in Hong Kong? And that is what I've been emphasizing every year, so that people have an answer to that question in trying to understand what our legal system is. It's not a concern. It's just that I want people to understand what our legal system is. It is important for me. It is important for the judiciary that there is confidence in the legal system. I don't mean by this that judges are liked, and for all I know, judges are disliked. That doesn't matter. What matters is there's a confidence in the system. Why it is important is that we may have a great system, let's say. We may have a system which is admired by everybody around the world, but if the people who are affected by this system don't have confidence in this system, then that is a cause for concern. Now, if it's because of ignorance and not knowing what the system is, then of course I would want to do more to help people understand what the system is. I go back to a question which I posed rhetorically. Most people when they criticize judgments or praise judgments, are asking really the question, why have the courts decided the way it has? Why has this judge done what he or she has done? Why have you convicted these people? Why have you not convicted these people? And so on and so forth. And the answer to that, because there are a lot of theories which come up, oh, it may be political bias, it may be you've been influenced by some other factors or by people and so on. The answer always lies simply in reading the judgment. I know it is hard to read a judgment, it is far too long, but it is long for one reason. It is long because it is meant to show precisely and in detail each step which is relied on to reach a result, and hoping then people will understand that what the court has done is to look at the law only as applied to the facts. And if the court has got that wrong, then it goes to one of the matters I've talked about just now. There is an appeal system going to the Court of Appeal and ultimately to the Court of Final Appeal. I want the public to understand the system. It's not quite right to put it the question in the terms you have, because I'm going to answer it on the basis that there are, of course, many comments one sees from people on the internet, sometimes in the newspapers. Sometimes these comments are well informed, and that is good because everybody has the freedom of speech, and it is right that people do comment on the system. Whether in a negative way or in a positive way doesn't matter. It is good that people take an interest in the system. And indeed, criticism is good when it is constructive. It is not good when it is not informed. And still less is it good or acceptable if it's just sheer abuse. 係你。
其實咧，你頭先都提到咧，係透明度咧，其實都好重要。咁而記者嘅角色都好緊要啦。咁但係咧，過去喺一啲法庭嘅案件入邊咧，好多記者咧曾經試過受到唔同嘅阻撓，冇辦法，甚至試過冇辦法入庭去做採訪。咁所以想問下，即係司法機構會唔會有咩方法去改善或者確保俾傳媒去採訪嘅透明度可以提高？
即係而家你係即係所有啲嗰啲 court proceedings 咧，你都可以去㗎。大部分，但係都曾經試過有好多爭議，即係試過有爭議性嘅案件，我哋試過入唔到法庭去聽。即係你意思係咪太多人係嘛？啲人走晒都唔俾得你。呢個唔係好明。因為你傳媒一定係你特別嘅，即係好似喺終審庭嗰度咧，你有特別有個房，你可以睇電視㗎。我哋都曾經試過個庭入邊嘅人清晒 suppose 記者可以入，但都曾經試過俾人阻撓，話記者唔入得。但係呢個我未聽過喎，就係人唔俾嘅喎。我唔知道，我相信可能我唔知道你係講緊咩 incident 咧，唔知係咪溝通？係咩？呢個你要話俾我哋知，因為呢個係對我嚟講係新，我未聽過嘅喎。係咩情況？即係冇意思，我要問你咁多嘢。不過我都未聽過，就係好似任何人，特別係傳媒咧，係唔俾佢入法庭嘅。但係即係如果係有咁嘅事咧，就唔應該發生㗎啦。冇即係 unless 係特別有啲特別嘅情況，好似特別 confidential， 我唔知嚇。
There have been concerns over threats to freedom of speech here, and the banning of the political party to denying the visa of a journalist, a foreign journalist who simply defended free speech. So are these acts by the Hong Kong's authorities incompatible with the common law definition of freedom of speech?
That sounds like one of the cases that may come up before the courts. And for that reason, it's not really convenient for you to answer this without, obviously, I think you understand why I don't make a comment on what is a sensible question. If it is something which may come up before the courts, it wouldn't be right for me to give a view, a legal view on it. It's a relevant question. Please understand that, but not really convenient for you to answer it for that reason. Hi.
想請教下兩方面嘅問題嘅，一方面就係都係問翻個方法啦，都係剛才有睇到話，其實係而家喺好多好莊嚴嘅場，即係你哋喺司法體系啲場合咧，其實都有播放一啲國歌嘅。 上嘅人咧就並非全部都係中國人啦，亦都有好多位有啲係外籍嘅法官，
即係海外嗰啲即係係。
其實佢哋即係你點睇咧？即係喺一個即係大家認為莊重嘅地方去播放，包括宣誓啦。咁但係到可能到頭落嚟就其實大家都未必係人人都識唱嘅時候，你覺得嗰個觀感或者外界會點樣去睇呢件事咧？第二咧就係
我答呢個先啦嚇。國歌咧就係大家要尊重。如果你唔識唱咧嚇，因為你唔識嘅字咧，咁就冇辦法啦，冇人可以逼你咁樣做噶啦。但係咧你 raise 一個好嘅 point 咧，就係我哋係當然有海外嘅法官，有啲係本地嘅法官，但對我哋嚟講咧，我哋唔會係分嘅嚇。其實我哋講有香港嘅法官，其實嗰個誓言咧，個 judicial oath 咧係一式係一樣嘅嚇，所以我哋唔會分嘅嚇。所以就算有啲係海外，當然係有海外嘅咧，有啲係本地嘅咧，佢哋係一樣，都係我哋叫香港嘅法官。
咁你如果而家喺 oath 嗰度都有分別啦，咁他人如果宣誓都要播歌，咁你覺得嗰個處理方法都有分別嘅？
咁就冇分別嘅。如果有播歌咁就係、就算你海外嘅法官、本地法官一樣啫。你嘅問題就係、如果係唱咧，如果你想唱咧，如果你唔識字咁，你冇法子啲地方就唱唔到噶啦，係咪？
想問翻，即係頭先都睇過即係嚟緊都有嗰個法官退休嗰個議案咧，即係嚟緊都會通過。係。咁但其實係咪
希望通過？
希望通過啦，但係咪若果通過到啦，或者即係as你哋 expected，係咪都係會點樣去加快處理到啲案件咧？定係還是嗰個問題，你哋會有啲乜嘢期望可以點樣去解決？
即係咩嗰啲案件啊？咩案件？
即係可能唔夠法官嘅話，
係
處理 case 嘅進度都
即係如果可以係即係 extend 嗰個退休嘅年齡咧，你就希望鼓勵多啲係有質素嘅律師，咁啊可以加入嘅司法機構噶啦。因為而家咧，好似你而家係嗰個退休年齡係65咧，如果你到咗60歲嘅，諗我仲有5年咧，你未必想申請即係加入司法機構。如果係到70歲咧，多啲人夠質素、夠經驗嘅律師咧，就會申請入司法機構噶啦，同埋咧唔使咁早退休咧，咁我哋多啲即係可以法官可以留喺度，即係。
我哋最後兩條。
都會關注近年即係 DOJ 就好似檢控多咗一啲政治人物啦，所以就你會唔會覺得即係可能 DOJ 係即係將呢啲政治人物嘅一啲案件咧係即係擺大眾上堂？另外就係即係會唔會即係好多時候佢哋會覺得即係 DOJ 係有無限，即係佢哋公帑咁樣去告，會唔會覺得係即係同案嘅時候即係佢哋係擺喺一個即係唔平等嘅關係上
？DOJ 係要咁樣去檢討，即係如果你係濫用咧，咁個可能就係。Right, OK， sorry，我以為就同你傾偈，唔好意思啊。係即係司法機構唔係控制，唔可以控制DOJ 係檢控或者唔檢控嘅啦。基本法第我都唔記得係幾條，60幾條係佢哋控制嘅。如果佢濫用咧，可能係有個法律嘅問題，我唔知但係呢個我哋控制嘅。
Follow up on the colleague's question about freedom of speech, without reference to any specific cases, but as a broad philosophical point, do you believe that freedom of speech, and the robust press we have here, play a role going forward in terms of protecting the rule of law?
That is a philosophical question, but I'm really here just to answer legal questions. What a lot of cases have held, decided by the CFA and other courts, is that the freedom of speech is valuable. It is an important right. It is not a right without limits. It's bound to have limits. The right itself, as stated in the Basic Law and the Bill of Rights, has inbuilt limits, such as you're not free to defame people. or to go overboard. But what I can say, because this is what a lot of cases have said, is that the freedom of speech is important and the freedom of the press is important. These are what cases have said.
And in terms of playing a role in protecting the rule of law?
Well, I mean, the courts are there to protect people's rights and freedoms. It's easy to say that. Sometimes the determination is not easy because there are many factors which haven't taken into account, many legal factors which pull in different directions. And that's what makes determining such cases difficult.
Mr. White, you have called for, in this year, you have called for the public to have confidence in the judiciary, which traditionally has always been the case. One of the sources of tension why you reconcile is that the state PRC has more and more been active and corrective and even been vocal of using some of the powers, including the interpretation that is coming from this court. Is it your position that how do we resolve and how do we handle this NPCSE's power, freestanding power, including some of the cases? Is there a way to properly constrain these powers so that the court, for instance, in somewhat of a recent judgment, there's a way to see forward to reinstate people's faith in this court, in the judiciary?
Since this is the last question, I'll give you a longish answer, which is this. The powers of interpretation of the Standing Committee of the National People's Congress is contained, of course, as you know, in the Basic Law, Article 158. The Court of Final Appeal has had several decisions which have dealt with the power, this power of the Standing Committee. I can name you a few which you know already. Lao Gongyong is one, Zhong Fangyuan is another, the Vallejos case is yet another, a more recent statement of those powers. So it is perfectly within their power to interpret the law. Now, turning to the role of the courts look at matters of law, looks at interpretations from a legal perspective. Now, again, I'm not going to say too much because there are a number of cases which will end up, which already are in the courts, which may well end up in the Court of Final Appeal at some stage. And these cases you already know about, co-location cases and other cases in which one has to consider a number of difficult areas. Now, here, obviously I'm not going to comment on the content, but what I will say is this: the courts will deal with it as it deals with any other case, carefully and in full accordance with the law. I'm not saying, I say this a lot, it doesn't mean it's easy. Sometimes it's extremely hard, and sometimes the result may not be to everybody's liking. In fact, I'm pretty sure that in terms of any case, a good half will not like it, whereas half may. Sometimes, which happened a year ago, everybody dislikes it. But that doesn't matter as far as judges and the courts are concerned. We adhere to principle, and that's what I hope the public understands to be the role of the courts, to adhere to principle, and in particular, legal principle. Anyway. Okay.咁我就係可以俾你嘅司法機構嘅方面，即係如果係檢控嗰啲，即係我即係重複嘅就係呢個唔係司法機構嘅責任嘅。Okay, well, thank everybody, and see you again. Thank you very much.